Bismillah ar-Rahman ar-Rahim. Assalamu alaikum, dear brothers and sisters. Welcome to another program from Al-Ayn Canada regarding will writing, inshallah, with our honored guest of Sayyid Maulana Rizvi, inshallah. Before we begin, let us start by recitation of Quran from our dear brother Mujtaba Piruz, please. Brother Mujtaba, Bismillah.
Assalamu alaikum wa rahmatullah. أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. وسيق الذين اتقوا ربهم إلى الجنة زمرا حتى إذا جاءوها وفتحت أبوابها وقال لهم خزنتها سلام عليكم طبتم فادخلوها خالدين. وقالوا الحمد لله الذي صدقنا وعده وأورثنا الأرض نتبوأ من الجنة حيث نشاء فنعم أجر العاملين. وترى الملائكة حافين من حول العرش يسبحون بحمد ربهم وقضي بينهم بالحق وقيل الحمد لله رب العالمين. الله أكبر. يسألونك ماذا ينفقون قل ما أنفقتم من خير فللوالدين والأقربين واليتامى والمساكين وابن السبيل. قل ما أنفقتم من خير فللوالدين والأقربين واليتامى والمساكين وابن السبيل وما تفعلوا من خير فإن الله به عليم. صدق الله العلي العظيم. صلوا على محمد وآل محمد.
Bismillah ar-Rahman ar-Rahim. Thank you very much, Brother Mustafa, for that beautiful recitation. May Allah bless you and keep you helping the orphans, inshallah. Tonight, we've gathered here, inshallah, to take advantage of our dear scholar, Sayyid Maulana Muhammad Rizvi. And before we begin, I'd like to just point out that Al-Ayn Canada has a program, a campaign happening currently in Toronto and all of Canada to raise money for rebuilding homes for orphans. As we're at home, warm and comfortable, there are many orphans in Iraq and other places in the world that are suffering because of the winter and the cold weather. And Al-Ayn we're trying to rebuild some of their homes and give them comfort. So please give generously, donate. We've put the details of how to donate by e-transfer to info@alayn.ca. And also by phone number, you can always call, or if you have any questions regarding homes, regarding tax receipts, you can call 905-401-4072, and inshallah donate. Every dollar helps. Please do so and help this cause, and inshallah, may Allah bless you. This organization is completely under Sayyid Sistani's supervision, and Sheikh Rizvi will touch on that as well. So please go ahead and donate and help us rebuild homes for orphans. As Allah says in the Quran, Kalla bal la tukrimuna al-yatim. So for Allah to have mercy on us, we have to help the orphans. And inshallah, we do that with our actions tonight and help orphans have a warmer home, inshallah. Without further ado, I'd like to introduce, I know that there's no introduction required, but our dear Maulana Sayyid Muhammad Rizvi, who's a scholar, resident alim at JCC currently, and also he's had many publications, 15 different publications that we've taken advantage of. And also he's written books in regards to will writing and other topics as well. Without further ado, I'd like to hand the microphone to Maulana Rizvi, and inshallah after Maulana Rizvi we'll have a Q&A session. You can chat on YouTube, and inshallah we can take advantage of your questions as well. Bismillah, Sayyid Rizvi.
Assalamu alaikum, everyone. Am I able to share some slides also here?
Yes, Sayyidna.
أعوذ بالله من الشيطان اللعين الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين والصلاة والسلام على محمد وآله الطاهرين. Dear sisters and brothers in Iman, Assalamu alaikum wa rahmatullahi wa barakatuh. This program by Al-Ayn organization is about just educating people about the importance of writing an Islamic will. And as it was announced in the flyer that, the idea was that people would go and listen to the seminar I had a few years ago. And based on that basic information, then we will take, questions to further, clarify issues or talk about the details. But just for the sake of, keeping everybody on the same page, of information. Let me just very briefly go through some of the slides which are relevant here. And what I would like to do is basically can you see that gray background?
Yes, we can see.
Okay. So let us begin with the very fundamental question, that is writing an Islamic will necessary or not? Now, basically, if you look at the ayat of Quran and the sayings of the Ahlul Bayt, it has been highly recommended and emphasized, but it's not technically wajib. So if you ask me whether in Islam is it wajib to write a will or to make a will, there is no issue of wujub as such. The emphasis, however, has been there quite a lot in the Quran and the sayings of the Prophet and the Ahlul Bayt. However, there are certain situations where things change, and this is where we talk about the issue of hukm thanawi. The primary ruling is that, is writing a will necessary? No, it's not. It is not wajib. But then under certain situation, it becomes imperative to do that. For example, look at the situation we have in Canada. If you lived in India or Pakistan, Iran or Iraq, for example, and if there was an issue of inheritance, how to divide it, or if there is a dispute within the heirs, they go to the court there. And Pakistan, Iran, Iraq are Muslim countries. They are governed by the Sharia laws. India is a secular state. But even then, interestingly, when it comes to the family law in Islam, family law in India, regarding marriage, divorce, and inheritance, this is where you will see that even from the days before independence, during the British India time, it was a part of the constitution that, religious groups will be allowed to exercise their own religious values. So suppose a Shia family has dispute on the issue of inheritance. Even if they go to the secular court in India, the judge will actually rule according to the Ja'fari fiqh. One of the sources those days translated and used as a source for the judges in India was Shara al-Islam, sections of marriage, divorce, and inheritance. This is the book, Shara al-Islam is of, this is Hilli, Muhaqqiq Hilli, I think, or was it Allama Hilli? Anyway, so that was the textbooks which was used. And so what I'm saying is that if you were in India or Pakistan or Iran or Iraq, for example, and if the dispute goes to the court is going to judge according to the Sharia laws. Now you come here to Canada. What happens in Canada? In Canada, if there is a dispute, no. They don't recognize the Islamic laws as such. However, the Canadian laws allows individuals to make their own will. They can write whatever they want. And they do not necessarily have to say this is the Islamic will, although we talk about it as such. They can just say, this is my will. This is what I want. This is my wish, that this is how my estate is going to be divided. And that happens to be according to the Sharia, division. And so when the Canadian laws allow you to exercise your right to make sure that your estate is divided according to the Sharia laws, this is where we come to realize that not writing a will has serious consequences. Number one, in case of dispute, the government appoints a trustee who will look at this whole issue and, do the arbitration. And interestingly, the pay of that trustee will come from your estate. So number one, you're going to lose money there. Number two, your heirs might get more or less than the Sharia, than the shares specified for them in the Islamic laws. So one person might get more, so whatever he gets more than his or her share, that will be ghasbi, that will be haram for him. On the other hand, the person who got less, he's deprived, he's mazloom in this case. And so when you don't write a will, this is where the consequences would be that there will be a serious implication for the next generation. And therefore, I would say that looking at the circumstances in Canada, as a hukm thanawi, we will say it is imperative to write a will, especially when the law of the land allows that for us. Now, I'm not going into the details of how the Sharia laws are divided and things like that. I just want to give you some basic principles. Because I'm assuming you're going through the YouTube's video on that seminar that I had a few years ago. As far as the control on the taraka or the estate of an individual is concerned, this is where we have to realize that there could be three possible scenarios. Either you have absolute control on 100% of whatever you are living, and you can write whatever you want to do. That's one scenario. The second is you absolutely don't have any control. If you lived in the communist USSR, Marxist system, people don't really own anything. Everything is owned by the state. So you don't really have any control at all. Then we come to somewhere in between, where the person has partial control through his will about how the estate will be divided. And this is where we come to realize the importance of writing a will. If you don't have a will, then you don't have your say. And from these three possibilities, from the Islamic point of view, it is the partial control that a person has on his taraka and his estate after he dies. Of course, in his lifetime, he can do whatever he wants, but we are talking about what happens after he dies. Does he have any control or not? And so it brings me to what do we mean by partial control? Islam allows you absolute right to distribute up to 1/3, thuluth of your estate, provided you make a will, you make a wasiyyah. This is where we come to realize writing a wasiyyah becomes very important. Without that, you don't have that option there. And so you have this graph here. The pie basically is your entire estate, and you divide it into 1/3, 2/3. In the 1/3, you can write in your will whatever you want to do with it. Up to 1/3, you have absolute control on your estate. When it comes to the 2/3, you don't have any control on it. It must be distributed among your heirs according to the Sharia laws. This is where we talk about partial control that Islam has given to individuals on their estate after they die. And this can only be exercised, this 1/3 option can only be exercised if you write a will. If you don't write a will, then the entire 100% must be distributed among your heirs according to the Sharia laws. And so this also makes it very necessary, for us to have a will. Now, what is the estate that we are talking about? Basically, all the debts, legal or religious, and the wajib portion of the funeral expenses that has to be paid, 1/3 of the remaining, which will be dispersed according to your will, and the 2/3, which will be distributed among the heirs of the deceased. Now, this 1/3 issue becomes very handy in order to deal with some of the challenges and questions that we get these days. For example, one of the questions we get is that, well, Islam is not fair with the daughters as opposed to the sons, because according to the Quran itself, you know, when a let's say the father dies, the estate will be divided in such a way that, suppose if there is son and a daughter, the son will get 2/3 of the estate, 2/3, and the daughter will get 1/3 of it. So the share of the son will be double of the share of the daughter. Now, is this because of what we call, you know, a sexist issue? You know, things are not like that. Let me just go to another slide here for a moment. One of the usage of 1/3, you know, how do you use it? And this is where 1/3 option that which is given to you makes things very flexible. And when people have certain questions about the Qanun of Mirath, you know, the laws of inheritance in Islam, this is where they have to realize that Islam has made it very flexible. 2/3 you can't touch. It has to be divided according to the shares of your heirs given in the Quran. But the 1/3 you can always, you know, shift it around up to 1/3. For example, when we talk about this issue of son and the daughter, before I go to that example of the daughter, let me give you other possible, you know, usage of this 1/3. For example, we talk about charity. If somebody wants to do sadaqah on behalf of himself after he dies, or especially a sadaqah which can be self-generating, so it becomes sadaqah jariyah, perpetual, you know, charity for a long time. It can also be used to give to those relatives who have no share in the estate. For example, let's say a person is dying, and when he was old, you know, maybe his children didn't take care of him that much. Maybe a nephew was more helpful, or a niece, or a brother. Now, in presence of the children, the nephew or the brother of the nephew don't come into picture at all. So maybe you, out of your heart, you would say that, well, you know, my children will get their share, but I would like to also give something to this relative of mine who doesn't have any share in my estate, because he is related to me remotely. And those who are closer to me will bar others from inheriting. And so this is where you can use up to 1/3, not necessarily the whole amount, but you can dedicate a portion and say, I would like to give this to my niece or my nephew or my brother, you know, who took care of me during the difficult time. Or it could even be somebody outsider. You know, when I say outsider, means it could be not a family member. Actually, it could even be a non-Muslim person. Or you can give a portion of it in charity to an organization. So this 1/3 option that Islam has given to you makes things very flexible for you to do quite a lot as far as 1/3 is concerned. You can even give it to those relatives who are going to inherit from you, because they are the first degree relatives of yours, your parents, your wife or husband, and the children. So parents, children, and spouse, they will have their share for sure in 1/3. But you would like, you know, some of them will have less than the others. And this is where you feel that maybe this relative or that relative, even though they are from the first degree, their share is less and they are more in need than others. So you can use this 1/3 option here, basically to make things better for them, in a sense, giving them more that you would like. This 1/3 can also be used for fulfillment of your qaza prayers and fasting or hajj. And this is where, if you have this religious dain and debts on you, this is how you will be able to take care of it, and you don't leave that as a burden on your children. Now let me go to the scenario of the daughter. We know that in Islamic laws, the daughter gets half of a son's share. And so immediately the question comes up, oh, you are being sexist, you are racist, or you prefer male over the female. And this is a very common objection that people raise against the Islamic laws of inheritance. This is where you have to realize, you have to understand the overall value system of Islam. It is not a sexist issue. It is actually based on the level of financial responsibility that Islam has placed on certain family members as opposed to others. And this is where we have to realize that, for example, in a marriage situation, in a family situation, Islam says that the husband or the father is responsible to maintain and provide for the wife and the children. Even if your wife is earning, even if she is earning more than you, it is not her duty. Of course, she does it out of her love, and you appreciate that, of course. And this is what I'm saying to the sisters. Your heart is full of love for your family, and you do that, inshallah, and Allah will give you jaza. But it's not a duty on you. The duty is on the husband to provide. And this is where, when it comes to the time that one person, one generation dies, and the estate is now being divided among the second generation, Islam does not just arbitrarily come and say, okay, we'll just divide it equally. No, Islam has a vision about it. Islam looks at the level of responsibility, financial responsibility put on the individuals in the second generation. Wherever the burden is greater, the share has been given more. And this is where we come to this issue of the difference between the shares of the son versus the daughter. Remember, in Islam, rights are tied to responsibilities. There is nothing like rights in a vacuum. If there is a right and haqq, then there is also a duty and fard on the other side. It's the same side, two sides of the same coin. So the right on one side, the duty on the other side. So keeping that in mind, now let us look at the scenario. Somebody dies, let's say, and he has a son and a daughter. And we are assuming here, in a normal situation, somebody lived a normal span of life, and both his children are married. And so you have the son, and then you had a daughter. Among the two, who is responsible for maintenance and provision in the family? This is where we have to realize, when it comes to the daughter, it is the son-in-law who is responsible. The maintenance and provision of the daughter, now it becomes the responsibility of the son-in-law. On the other hand, the son is now married, and he has, three children. And now the son is responsible not only for himself, but also to provide for his wife and for his children. This is where we come to realize, in a normal situation, the son has a greater burden in the family life than compared to the daughter. And therefore, Islam then says that, we will divide the share of inheritance here in such a way that the daughter is not being deprived totally. She will get it, but it will be half of the share which is being given to the son. If you look at it from the other point of view, the son-in-law is also going to inherit, and he will inherit, let's say, more than his sister, so that he can provide to the wife and the children. So it is overall system. This is where you come to realize that Islam is not being sexist here. Islam is looking at the level of responsibilities. Now, you might say that I talked about a very normal situation, maybe where the husband, your son, is well-to-do, has a good income, is a good job or good business. He's able to take care of his wife and children comfortably. On the other hand, your daughter is married to somebody who is struggling financially, and you feel that, well, my son is already affluent. He doesn't need that much help from me. I would like to give more to my daughter because her family is struggling financially. This is where the issue of one-third option comes in, so that you can allocate some more shares to your daughter, to the extent that actually you can make it equal if they are just one son and one daughter. For example, if you did not exercise the sulus, the one-third option given to you, then your entire estate will be divided between the son and the daughter. We are talking about a very general situation here, that the son will get 66 point something and the daughter will get 33.3 something. But with the one-third option, you can actually change the numbers around. For example, 2/3 you can't touch. That has to be divided according to the Quranic share. So from that, the son will get 44 and the daughter will get 22. From the remaining 1/3, now you actually change the numbers there. And you give only 5.56 to your son and you give 27.78 to your daughter. By doing that, what is the end? The end is 50-50. And so this is one example that when we talk about the Islamic laws and when you hear about, the daughter getting half of the share of the son, yes, this is a general situation that we are talking about. That Islamic laws has this built-in, flexibility where the deceased is able to change things if according to, different scenarios and situations. Just as we looked at this example of a daughter who needs more than the son. Let me now just go very quickly to the, by the way, the book that I have talked about 36 or more scenarios, the most common ones, where people can go and look at the charts in the book and see what chart would be relevant to their own situation. And the charts deal with both scenarios. Let me just give you one example here, that you have a scenario of the man passing away and leaving a wife, a son, and a daughter. If he doesn't make the will or doesn't exercise his one-third option, then the wife will get 12.5% here. The daughter will get 29 something, and the son will get 58. If he uses the 1/3 option, then the shares will go down. The wife will get 8.3, the daughter 19 point something, the son 39.83, and then you have this remaining 33%, which you can move it around, give it to your wife, or give a portion of it to your wife and a portion for to your daughter if you want, or so it is up to you what you want to do about it. Let me now end with one last slide about it. When we talk about using the 1/3 for charity purpose, again, you can use 1/3 and divide that into different portions, one for charity, one for your own qada, prayers and things like that, or for giving it to your relatives and family members that you think that they need more. I would like to share with you, and this is also in my book, Sheikh Mufid's suggestion about how to use 1/3. He says the 1/3 you divide it into 4 portions: one for qaza, prayers and fasting and kafara, 1/4 for relatives who do not inherit, 1/4 for deserving poor sadat, and 1/4 for poor Shia in general. And this is where, basically you have this flexibility. It's just a very simple example I given from Sheikh Mufid. This is not cast in stone. Since we are talking about Al-Ayn, which takes care of the widow and the orphans in Iraq, and this is you can even include, for example, charity given a portion of it for Al-Ayn organization, or if you want to make it more a income generating donation, that also would be known as sadaqah jariyah. I will conclude here, and then inshallah, this is your time now, basically, to for your questions if you want. By the way, the mic is yours.
Thank you, Maulana. I'm just waiting to see, get the questions, inshallah. Waiting for questions, inshallah. If there's any questions, brothers and sisters, please go ahead and send it to on the YouTube chat, and inshallah we can answer your questions, inshallah. Again, before I'm waiting for questions. If there is any brothers and sisters that would like to donate towards the orphans tonight, please do so at info@alain.ca, or the phone number that's on the screen as well. You can go ahead and donate towards the campaign, inshallah, Rebuilding Homes, and may Allah bless you. One question I have, Sid Rizvi, is that I leave behind 2 young kids and a wife. Can I leave everything to my wife? Maintenance of house, since she does not work. The kids are young to understand to waive the rents.
In that scenario, I think it's important to sit down with the family, and you can leave everything to the wife with the understanding that the children have their share in it. However, because they are minor and they are not capable of handling their own issues, so you can even appoint the wife to be the guardian, to manage their part of the estate until they become capable enough. It doesn't mean they have to become baligh. They have to become Rashid. They should have this maturity of handling the finance. So it's not just the age of bulugh. No, until they reach to this age. For example, in Canada, normally they put it at the age 21, and that's where then she can hand over their shares to them. So this issue has to be mentioned very clearly. You might be able to just write it in the paper that in the will that I'm giving everything to my wife, but I think you need to have a commitment from your wife on this issue, that not everything goes to her. And so this is something that you had to deal with it very clearly. The other thing I would say is that when it comes to the some of the major assets like residential home or even bank accounts, mostly here in Canada, it's all in the name of both spouses. And according to Canadian laws, when one dies, everything goes into the ownership of the surviving spouse. And so there is a mechanism of how do you allow that to happen from the Sharia point of view. And this is where I would refer you to go and look at the book, because I talked about it, especially when it comes to the share of the wife.
Yeah.
Since we are at that, let me just explain one more thing, that inshallah we've been looking at some in the book. I only covered 36 very common scenarios of inheritance and given the shares there. But people have been asking this question that maybe, my case, I didn't find it in your book. You're talking about children and the parents. We don't have any children. We are only a husband and wife. What do we do? Or I have brothers also. No parents, no children. So they become on the second degree of relationship and they have a share, but your book doesn't have the chart for it. We have been working on it, and inshallah in January we are going to come up with a new update version of it. There will be a seminar at the JCC on it, and an app will be launched at that time where you will have the flexibility of going there and putting on your scenario. Who are your potential heirs, and it will automatically generate the numbers for your case, inshallah. But we're working on it. In January, inshallah, it should be ready.
Inshallah. So, Maulana, I'm getting a lot of questions, but some of the questions are very related, so I'll link all of them together, inshallah. One question, Assalamu alaikum, Maulana Rizvi. My question is, do we need to register an Islamic will in Canada as per local laws? And also another question is, are the Islamic inheritance law affected by the Canadian inheritance law?
Number one, when it comes to registering your will somewhere, no, you don't have to register it anywhere. The format we have given in the book gives you the normal format where after you are writing your things, at the end you will sign, and there will be two witnesses when you are signing, and those two witnesses will sign, basically verifying that you are the one who signed it. And that is a legally sufficient document. You don't have to get it, certified by a lawyer, or go anywhere to get it registered, unless you are a billionaire and you have very complicated things. Then you better get a lawyer for it. Otherwise, people, normal average citizen, you don't need to go and register anywhere. Actually, by law, if your will is written, not typed, handwritten, then you don't even need witnesses. But there will be a problem there. If there is a dispute, they will have to send it to the experts to verify with your existing, handwriting, to compare with whether this is yours or not. And so you don't need to go and register anywhere. The first one. The second question was, would it be recognized here? As I said earlier, Canadian laws allow you to write whatever you want in your will. Sometimes you hear these, millionaires in New York, for example, dedicating large portion for their dog and cat. This is a secular world. They allow all this thing. I'm saying, why don't you exercise that right that you have? And don't necessarily say this is Islamic will. Just say this is my will, but make it according to the Islamic laws. That would stand in the court if it's challenged, and it will be acceptable.
So there's some questions about properties. I'll combine some of the questions together. One is saying, if I own a portion of my house while the other portion is owned by other family members, not my spouse, how does distribution of my portion work? If I own property via proxy, via my spouse, how does distribution of that portion work?
Okay, in the first scenario where you have other family members who are co-owner of the property, then upon your demise, your share of that property becomes part of your estate, and the other partners either have to buy your share, means from the heirs, or they will have to sell it in order for your heirs to get their share in it, and then that will be that will become part of your overall estate and divided accordingly.
Another question is, if you're single with no kids and have siblings and parents, how does Sharia divide that?
You see, we had this chart there that the first, let us call them the first degree relatives, parents and children. Anyone from them is, if alive, the siblings don't come into picture, the uncles don't come into picture. The grandparents, if they are alive, they don't come into picture. But if, let's say, you don't have any children, only your parents, since your parents are from the first degree, they will be inheriting from you. The siblings, the brother or the sisters, will only come into picture if there is nobody from the first degree relatives. So if a person is living only, let's say, mother, and nobody else, no children, then the parent, whether the father or the mother, will inherit. And when it comes to the issue of when there is nobody from the first degree, that's where the brothers will come into picture, brothers or sisters.
There is a question, I think you answered that previously in your lecture. Is writing a will mostly for men? If it's for women too, how would they have to do it in the best way?
The writing of the will actually should be for both husband and wife, and only the numbers will change. The shares of the husband would be different from the shares of the wife. The children would be same. So, of course, the children's share would be affected by the numbers of the spouse or the parents. And so, I think both have to have their own wills according to their own scenarios. For
Could you speak?
example, the husband doesn't have parents, only the wife and the children. Then his will only state about the share of the wife and the children. But maybe the wife has the mother also. So the wife's will reflect the share of the mother and the husband and the children. So both need to have their own separate wills.
Could you speak a little bit about the difference between the Sunni and the Shia in inheritance law? It seems that they do not have the rule about 3 tiers, and they have a requirement to leave 1/3 to charity.
The last question was more simpler. No, there's no issue of requirement of leaving anything as a mandatory thing for charity. No. The only thing is that when it comes to the issue of the daughter, they have a different perspective, and it's all goes back to the politics regarding the haqq of Fatima al-Zahra salawatullah alayha. It even changed the laws. So, for example, in the Shi'i perspective, if the parents are dead and this person has only one daughter, she gets 100% of the inheritance. 50 as part of her Quranic share, and the 50 because nobody else is there from her class, so she gets the other remaining also. But in the Sunni laws of inheritance, the daughter only gets half the only daughter there, gets half, and the other half will go to the second degree relatives. So the brothers or sisters or the uncle and aunts will come into picture there. That's the main difference. There are some other fine points, but I don't think we can go into details here. No.
Well, they're asking. There's a lot of questions about, do we have to involve a lawyer? I think you answered that. You can just do a handwriting. You don't have to. That 100% involve a lawyer. But a lot of people are asking where they can find the template of a will. If you can direct them towards, I think the site that we emailed to them as well. We can, if they have any request, but if you can guide them as well.
Yeah, you can look at the book, which is available at the website is al-m for Muhammad, alm.ca. Very simple, al-ma'arif. And the app also would be made available on that website, where you'll be able to actually put in your potential heirs, and it will actually generate for you a format according to your information, which you can then download and look at it and change the way you want, and that would be the simplest way of doing it.
Well, we've shared that link on our chat. So on the YouTube chat, you can take that link and Maulana just mentioned, and you can access it right away. Maulana, another question is it permissible to use a legal will to give everything to your spouse for tax purposes and attach a condition in the form of a memorandum to instruct the spouse to divide based on the Sharia division of it, clearly spells out the percentages?
You can do that. I don't see a problem there, as long as you trust your husband or your wife. If the trust level is there, yeah, you can do that. And many people actually do that because of this taxation issue. So basically, the children will only inherit. The shares will come to them later on or after the other parent has passed away.
Okay. How does my home get distributed as part of my estate if I have two sons and a house is in the name of myself and my wife?
You see, there is a challenge we have, because when you look at the property, it's in the name of the wife and the husband. So according to Islam, Canadian laws, when one dies, the other becomes the owner of the entire property. So if the husband dies, the house now becomes the property of the wife entirely. Whereas from our Sharia perspective, since they were both the owners, their right is actually only 50-50. So from the Sharia point of view, when the husband dies, half of the house belongs to the wife as her share from before, not as part of inheritance, because she was the owner, co-owner there. Other half becomes part of the inheritance. And so there are ways of using the Sharia technical points to resolve this problem. One is that if the overall value of the estate of the husband, for example, is such that the 50% of the house would be under 1/3 of the total, then he can always make a will and say that my portion of the house is part of my 1/3 will, and I am giving that to my wife. So then, even from the Sharia point of view, the entire house, 50% is hers anyway, and the other half also will go to her. Or there is one option that we have given in the book, that both husband and wife can actually do the hiba. They can give their portion of the house to the other, with the condition that as long as you are alive, this my portion is also belongs to you. But if you die before me, it reverts back to me. So this is not a transaction. This is more a gift deed, which is conditional to life. As long as you're alive, this is yours. So if the husband dies, then this is where it becomes her property entirely. So there are some what we call Shari mechanism that we have suggested, and there is also one way of doing it. Inshallah, we'll talk about it in January.
If you're a widow, can you leave 1/3 to your children and leave 2/3 to charity?
No, you cannot do that. You can do the other way around. 1/3 to charity and 2/3 has to go to your children. However, if your children are mature enough to understand these issues, and if you sit down with them and you say, all of you are okay, I've given you enough, so I would like to give more in charity and less from your share. If they agree to that, to give up their share, then their consent would be valid, and their consent, when it's given, that's final. They cannot go back on it. So yes, it can be done, provided you get the consent from the potential heirs, which are your children in this scenario of the case of the question.
Well, if you have a child that's passed away, you don't have to include him in your will. You have to give it to the live ones, correct?
The inheritance only goes to those who are surviving, who are alive. So suppose somebody had 4 sons, for example, and one of them died in the lifetime of the father or the mother. When they die, the parents, the inheritance goes to the surviving sons, not that one who died. However, this is where the 1/3 again becomes very handy. Suppose that son who died in the lifetime of their parents was also married and has children, so they are yatim, and the grandparents would like to help them out. They can always use that 1/3 option and give a share of it to their grandchildren. So this is where again, one more scenario where 1/3 can become very useful.
Okay. What about wife's jewelry? If there is a daughter and 2 sons present, can the jewelry be allocated to the daughter?
So yes, so the scenario is that the mother is died now. And we're talking the.
Yeah, that's a good question. I'm not sure about that. That's all mentioned.
I think that's what is meant. So the mother dies, and she has jewelry, and she has a son and a daughter. Well, technically speaking, no. It has to be divided according to Sharia, 1/3, 2/3. She can actually, in cases, this is what I would say normally, if they reach to that age where major parts of the jewelry, they should actually just give it away in their lifetime to their daughters and daughter-in-laws. Distribute it just in lifetime, so there's no friction and tension and fight afterwards.
Please explain if it's recommended to express our belief or the belief in our will.
It is recommended to do that, where you start with saying that, I believe in one God and Muhammad is my Rasul, and Ali is my Wali and the Khalifa after Rasul, and the list of the A'immah then comes, and the Quran is, the book that I believe in. So yes, you can, and there are some formats available. But here I would say, because I look at the scenario here in Canada, unfortunately, in 90s, there was a campaign against Sharia law by Muslims who are actually anti-Islam, so-called Muslims, spearheaded by some of the Iranian ladies actually those days. I don't want to single them out, but they were saying, oh, Sharia law means they are going to flog people and they are going to cut hands and then they're going to hang people. Oh, we were talking about the Sharia laws, the Muslims in general. In early 90s, there was a campaign to have arbitration board by Muslim organizations to deal with, financial disputes and things like that. And so there was a huge campaign against Sharia law. Now, so the word Sharia has become kind of sensitive. As soon as you mention that in the court, these judges and lawyers, their antenna will go up. The red flag comes up. So I would suggest write your will according to the Sharia, but don't say this is Islamic or Shari. Let it be Shari without saying it is Shari.
Okay.
Because you don't want to create any kind of, bias right in the beginning of your case if it goes to court against that will.
So we'll have about 3 more questions. I know Maulana is tired as well, so I'm not going to keep you for long. So we'll ask 3 more questions, inshallah, and we'll end. If an asset has a designated beneficiary, is it included in this? Is it included in the state? Not life insurance, but a retirement fund, for example.
Retirement funds actually would be part of the estate. Life insurance is different. That doesn't become part of the estate. It goes to the beneficiary directly because it was a money which only generated upon the demise of the person. But when it comes to the retirement fund, no, that belongs to the deceased. And because it belongs to the deceased, it will become part of the estate.
There's a beautiful question that's right up the alley here. Maulana, they're asking, is there an organization for charity that you completely trust and you visited and you can recommend?
You're putting me in sport here. Huh? I'm talking in an Al-Ayn program.
That was a beautiful question. I couldn't resist.
There are different organizations which are trustworthy. Since we are talking in this program of Al-Ayn, yes, actually, I'm not really. It's an honor actually that I am the person who introduced Al-Ayn in Canada in the first place. As far as our JCC and ISIJ is concerned, this was based on my visit a few years ago in Iraq. I was able to see how they work there. There was no branch here in Canada at that time, and I saw their headquarters in Kazimain and how they operate, and I was really impressed with the way they conduct themselves. Very organized and very transparent. Better than any other organization that I've seen around the world. Yes.
Last question, Maulana, and inshallah we'll end the program. Can you ask your elderly parents to give up their share as well, so that you leave everything just to spouse and kids? What's the best way to record this consent? Should it be in the will? And also, can you email your will to 2 people, and is that enough?
Well, as far as the issue of will is concerned, you have to have the 2 witnesses there. Just for the sake of record keeping, yeah, you can scan it and give it to your closest relatives, so when there is a need to look for it, they don't have to go and find it. Or if you put it somewhere in your safety box or something like that, make sure the family members know where to look for it. As far as the first question about elderly parents, yes, you can ask them whether they want to give up their share. And if they give the consent, that is sufficient. It doesn't have to be in writing. So based on that, you can then write your will. Yeah. And as I said earlier, any potential heir who gives up their share, that would be final. They cannot then go back on it.
Thank you very much, Maulana Rizvi. I can't thank you enough from everybody that took advantage of this event, and also myself and the orphans. May Allah bless you for always being behind the orphans and the needy, and keep you for us, inshallah. Thank you very much, Maulana Rizvi.
Yeah, let me just remembering one scene that I saw in my first visit of Al-Ayn headquarters in Kazimain. It was really, I was surprised, first of all, knowing the situation in Iraq, post-Saddam era. Things were not that, organized. But they took me around to the main hall and this was just one sample of how they do in their different branches in the Shia, areas of southern Iraq, in different cities, Karbala, Najaf, Basra, and other places in Baghdad. It's more like a government office. The mostly ladies, they would come and sit in the chair. When they walk in, they pick a number, like we see here, where we go for our passport office or something like that. And there are some booths there with the electronic numbers coming up. When the number of that particular lady will come up, she will go there, show her electronic card, and they will just scan it, and they will know how much, what is her background and how many orphans are there, and they will give the monthly money which is due for her. And most importantly, there was last booth there where there was a lady, muhajjaba lady, sitting there, who is kind of a learned lady in religion as well as in psychology. And she would be available for any widow who wants to share her, personal, challenges or difficulties that she's going through. And so it is a very unique, program that they started. May Allah subhanahu wa ta'ala give the tawfiq to them. It is very well, organized, very efficient. And as I said, it is very transparent as far as the utilization of the funds is concerned. Assalamu alaikum wa rahmatullah.
Wa alaikum assalam. Dear audience, just to let you know, you will be receiving a survey, inshallah. Let us know how we did in our event, and inshallah, what kind of other events that you're looking forward to. And inshallah, we'll try to provide those and take advantage of our knowledgeable scholars as well. Don't forget to give charity tonight towards orphans. May Allah bless you. Every dollar helps an orphan, so please do so. Links are above at info@alayn.ca, and also the phone number mentioned on the screen. Thank you very much. We'll end with a dua faraj, inshallah. Bismillahir Rahmanir Rahim. Allahumma kun li waliyik الحجة ابن الحسن صلواتك عليه وعلى آبائه في هذه الساعة وفي كل ساعة وليا وحافظا وقاعدا وناصرا ودليلا وعينا حتى تسكنه أرضك وتمتعه فيها طويلا برحمتك يا أرحم الراحمين. مولانا رزوی التماس دعا خدا حافظ.
هاي منطقتنا كلش حلوة، شوارعها نظيفة ومبلطة، وبيها منتزه نلعب بيه أني وإخواني. دائما نرجع من وقت للبيت لأن ماما ما تقبل نتأخر. أول ما نوصل نسبح بحمامنا الدافي وماما تسوي لنا أكل ونتفرج تلفزيون ونلعب ونحل واجباتنا، ومن يصير الليل نتغطى زين لأن هاي السنة الشتاء كلش بارد. تصبحون على خير.